Okay, so the issue that we continue to confront is whether aviation tenants are required at Santa Monica Airport. And so what I did was went through the agreements, and the 1984 agreement does require aviation tenants. The 1994 grant agreement does not require. The 1948 instrument of transfer does not require. The Part 16 dispute resolution process does not require aviation tenants. The 1973, 75, and 99 federal case law all state that the proprietor can choose whether or not the airport has aviation tenants. And the 1978 Congressional Act also says that it is the option of the proprietor as to choose its tenants. So the conclusion is that after July 1st, 2015, aviation tenants are not required at the airport. The 1984 Santa Monica Airport Agreement has one provision that states that we have to rent space to aviation companies. The city must rent land and buildings to aircraft companies until July 1st, 2015. So we have a contract with the FAA that was the result of a settlement discussion, and when that contract expires, we no longer have the obligation to rent space to aviation tenants. The 1994 grant assurances do not require aviation tenants. In the City Attorney's 2014 Part 16 response, she stated, complainants have no right to be lessees at SMO for any specific and guaranteed length of time in the future, whether it be for 1 year, 3 years, or 8 years. This subject is well beyond even the most liberal and expansive interpretation of the FAA's authority and power to exercise control over the airport sponsors. So the city attorney agrees with this position that aviation tenants are not required after July 1st, 2015. And what I found interesting in going through the lawsuit is when the court dismissed the 2013 declaratory relief action, we tend to think that the court is very biased towards the FAA because of their administrative rights, but at the end of their statement, it says this court finds it unnecessary to resolve this factual dispute in ruling on this motion and will assume that the city's grant agreement obligations expire in 2014. The court did not take the position or assume that they expired in 2023 as the FAA stated, but instead thought they expired in June 2014. The 1948 instrument of transfer does not require aviation tenants. It says that if you have aviation tenants, you can't grant exclusive rights, or if you have aviation tenants, you can't grant them rights on a discriminatory basis, but it does not require the proprietor to actually have aviation tenants. The next part of this is, what is the penalty if we don't have aviation tenants? And we're always concerned about getting put into a Part 16 hearing. And we've seen this slide before, but this is the letter from 2005 where the FAA told us that we weren't in compliance with the grant assurances, and as a result, they were going to withhold future federal funding. And they cite a number of code sections there. And the applicable code section is U.S. Code 47196. And under this section it says the Secretary may withhold approval of an application under the subchapter for amounts apportioned under Section 41114C and E of this subtitle for violating an assurance or requirement of this subchapter if, and then there are some reasons that are cited, but basically the penalty for non-compliance is that they withhold federal funds. This is another FAA Director's determination from 2003 for the Naples Airport Authority. Again, it's exact same language. They said, because you failed to comply with the grant assurances, we are going to withhold any applications, withhold approval for applications submitted by the NAA for amounts apportioned under this code section. The Naples Airport Authority wanted federal funds. They wanted to continue to receive federal funds, so they appealed the FAA's decision, and the Court of Appeals reversed the FAA's decision and vacated the order not to grant Naples any more airport funds. So, again, we believe that the courts are very deferential towards the FAA, but in this case, the court took the position that the FAA did not prove that the city's position, or that the Naples Airport Authority position, was unreasonable, and therefore vacated the FAA's order. So, again, the courts are not deferential towards the FAA. So we just talked about the courts. Now we're talking about case law. There are multiple pieces of case law that support the position that the proprietor has the right to do what it wants to do at the airport. In this 1973 Supreme Court decision, the court ruled that aircraft owners acting as proprietors can presently deny the use of their airports to aircraft on the basis of noise considerations, so long as the exclusion is non-discriminatory. And they specifically stated that the FAA has been given broad authority to regulate the use of navigable airspace in order to ensure the safety of aircraft and the efficient utilization of airspace and for the protection of persons and properties on the ground. But it did specify that the proprietor still has the right to determine the type of aircraft or to make certain exclusions on the basis of noise considerations. In 1975, the district court ruled in the Crotty case that proprietor's control necessarily includes the basic right to determine the type of air surface given airport proprietor wants its facilities provide, as well as the type of aircraft to utilize those facilities. The intent of Congress is not to interfere with such basic airport control as is made clear by the legislative history in Section 611 of the Federal Aviation Act of 1958. In 1999, again, the Court of Appeals said, "We conclude from the foregoing authorities that local governments retain their power to regulate land use even with regard to safety and noise control, so long as it does not touch upon control of aircraft or airspace or any aspect of aviation navigation." Now, this is very important because what we're talking about with lessees or leases at the airport is land use. It's not dealing with navigable airspace. It's not dealing with the runway. It is solely dealing with land use. In 1978, the Congress passed the Airline Deregulation Act of 1978, and in it, it states proprietary rights and powers. Nothing in this subsection A of this section shall be construed to limit the authority of any state or local subdivision to exercise its proprietary power and rights. So again, it asserted in 1978 that the proprietor still had the right to exercise proprietary control over the airport. In the August 2014 City Council meeting, the City Council members asked various questions about the airport. So I'm just going to run through them briefly, and then we'll go one by one through these questions. First, Council Member Vasquez asked, there are many of us on the Council to see if there's a way to separate legally aviation uses versus non-aviation uses. Council Member Winter asked, the question, continuing leases month to month, wouldn't they preclude us from raising rents to market, including some of the aviation interests which are currently paying substantially below market rate? Councilmember Winter again asked, if we went to month, we would create a de facto subsidy by charging below market rate rents for some of the aviation lessees. Is that correct? And then finally, Councilmember Winter asked, can we bifurcate the non-aviation lessees and the aviation interests and treat them differently? And I understand that it is your belief that this is a legal quagmire. So going back to their questions, can the aviation and non-aviation land be separated? It already is. Can month-to-month leases be increased to market rate? Yes. Will month-to-month lease will month-to-month leases create a subsidy? No, they won't. Is it a legal quagmire to stop aviation leases? No. I mean, these are my opinions, and I'll share with you why. With respect to separating the aviation and non-aviation land, the response when we've asked this question in the past is that it can't be separated because it's all part of the airport campus. My interpretation, based upon reading the 1984 Santa Monica Airport Agreement, is that they were separated by Section 6. This is the airport layout plan that's attached to the 84 agreement. The cross-hatched area in the bottom is designated as residual lands. This is Section 6 of the 1984 agreement, and it says that the FAA will release the use of this land from aviation use as soon as we sign leases with FBOs to comply with another provision of this agreement. In the 2013 litigation with the FAA, when we filed our declaratory relief action against them, the FAA even acknowledged here, it says, plaintiff's contention with respect to the 1956 release and the 1984 releases are similarly without merit. So here the FAA is acknowledging that that land was released in 1984. So if you look at a close-up of this land includes Barker Hangar and Proteus Aviation on the north side of Airport Avenue, and then it also includes the Santa Monica Art Studios and the Antiques and the 3,300 and 3,400 buildings, which 34 I think is the Lear building, but it clearly releases all of these pieces of land from aviation use. So this is our airport map, and you can see the non-aviation parcel at the bottom, and it has Barker Hangar at the top and all the various buildings at the bottom and their addresses. The next question was, can month-to-month lease be increased to market rate? Staff response is no. If we continue leases month to month, we would not be able to go back to market rates. My response is yes. By the terms of a month-to-month lease, absent rent control law, the rental rate you can raise the rental rate each month. So if we look at the non-aviation parcel rents at market rate, currently we get about $1.6 million from those. So they're almost at market rate for all of the properties that the staff has control over. They have done a very good job at keeping these non-aviation properties at market rate. You can see the two large corrections, market rate adjustments. One is Barker Hangar, which rents for about $100,000 a month, and at a market rate it would rent for about $400,000 a month. So, but we can't raise rates on that lease because that was considered an aviation lease under the 1984 agreement, and the 84 agreement required us to charge rates and fees to allow the aviation business to run a successful business. But as soon as that agreement expires on July 1st, 2015, we no longer have to subsidize those businesses. And the other large market rate correction or adjustment is the Santa Monica Art Studios, which is a policy by the City of Santa Monica and the Santa Monica City Council, who intentionally offered that lease at a low rate. The problem is that the master leaseholder is getting a discount on it, but he's turning around and charging the subtenants a market rate, so he's making a big profit, and the arts tenants aren't really benefiting from the city's arts policy. So, when this lease expires in 2014 or 2015, it may be a good idea for the city to take that over through a leasing agent so that the arts tenants can actually benefit from the city's policy. But anyway, we have to give our commendation to city staff for doing a good job of keeping the properties that they have control at market rate. Now the aviation parcel is a completely different story. We currently get about 1.1 million of rents from the aviation land, and they're collecting about $9 million worth of rent from their subtenants. And what's interesting is, there's concern that we're not going to release this land to aviation tenants, but currently 87 to 88% of the airport is occupied by non-aviation tenants. And the reason being is that the aviation tenants who control buildings and have the right to lease to aviation or non-aviation tenants are leasing primarily to non-aviation tenants because they pay current market rates. The current market rates are $3 a foot for buildings and $1 to $2 for hangars. And so just by virtue of capitalism, or the market, letting the market control the price, the aviation tenants are disposed or predisposed to lease it to the highest paying occupant, and so the highest paying occupants are non-aviation tenants. So there's no discrimination here, or if there is discrimination, it's discrimination on the basis of economics, and the aviation tenants are discriminating against other aviation tenants and leasing to non-aviation tenants. So it's hard for them to make an argument that we should be subsidizing aviation tenants when they are not doing it to line their own pockets. Now, if we look at the aviation parcel subtenant rents, the subtenant rents are basically at market rate. You can see they're getting about $8 million, and in looking at the hangars, we're essentially renting the hangars for between $1.50 and $2 a foot, and if you go to public storage, you generally pay about $3 a foot for storage space. And these are special storage spaces because they're in a secured area and they have some other benefits to them. So, I think that we could easily push those up another $1 million in rents. And, on July 1st, 2015, when the master leases expire and these buildings revert to the city is going to get that $9 million of rent without raising any rents. Now, this is a breakdown of what the current composition of the airport is on a square foot basis and on a building rent basis at market rate. And so for the existing non-aviation tenants on aviation land, they're all at market rate. But if we take up the aviation buildings, and there really aren't many of them, it's American Flyers, it's Kruger, it's Proteus, which is really non-aviation building, but there are very few purely aviation buildings with just aviation tenants in them. But if we look at this, we can see that non-aviation tenants make up 87 to 88% of the airport, or the tenants at the airport, and the aviation tenants only make up 12 to 13% of the tenancies at the airport. And the aviation tenants are paying significantly below market rates, and the non-aviation tenants are almost all paying market rate. This was another response to can month-to-month leases be increased to market rate. Staff has thought long and hard about trying to raise rates to forestall drains on the general fund, and that's very true. But staff has done a very good job for the tenants that they could control to keeping them at market rate. And essentially, the airport is at market rate right now, except for the aviation tenants. I mean, I would even advocate to the City Council that they just use the market rates that Stelios is charging the other airport tenants to charge the aviation tenants, and that is absolutely non-discriminatory because the aviation tenants themselves are charging these rates to non-aviation tenants, and the city staff is charging these rates to non-aviation tenants. So there is no discrimination. There is nothing unfair about it, and on the contrary, it's a gift of public funds to subsidize these for-profit businesses with taxpayer dollars. The next question was, will month-to-month lease create subsidy? the staff response was certainly aviation tenants would continue to make huge amounts of money renting the space out at market rate. My response to that is untrue. Either the aviation master lease would be increased to market, or the city would enter direct month-to-month leases with the subtenants. And let me give you an example of that. Here's the Atlantic Aviation Master Lease. Currently, they pay $200,000 of ground rent to the city each year. Each year, they collect $4 million of rents. And honestly, this is a 2012 number. I don't have an accurate 2015 number, but I'm giving you this 2012 number. So the spread is $3.8 million. So on July 1st, 2015, as a landlord, you would go to Atlantic and say, okay, your rental rate is now being increased to $4 million. So you can pay us 1/12 of that each month on a monthly basis, which is $333,333, or you can forgive the lease, or you can vacate the premises. The city doesn't have to do that. The city can also enter a direct lease with Atlantic Aviation, or with all the subtenants, and just collect the rents directly, and basically offer Atlantic Aviation a sublease if they even lease any square footage in the building. Based upon the rent rolls that were provided to me, I was unable to decipher that. So there would be no subsidy. All of the profit would go to the city and would help repay the general fund for all the loans that the city has made to the airport. The next question was, is it a legal quagmire to stop aviation leases? Staff response is, I don't have any doubt that the federal government would challenge a leasing policy to change the use of the airport from an aviation facility to an artist community. My response is, the leasing policy is to control land use, not to modify the use of the aviation facility. And this is an important distinction. The land use deals with tenants and buildings and rents. The aviation facility is the airport. It is the runway, and that is what we have to keep open for public use. And this proposal is not proposing to close the airport or modify the runway that is constrained by our federal agreements. And then the city has already leased 88% of the buildings, and I really shouldn't say the city, I should say the city and the aviation tenants have already leased 88% of the buildings to non-aviation uses without any objection from the FAA, and that's because it's a land use issue. It is not a discriminatory issue of an airport sponsor. Again, we go back to the proprietor's rights, and again, the Crotty case says, manifestly such proprietary control necessarily includes the basic right to determine the type of air service airport or a given airport proprietor wants its facilities to provide, as well as the type of aircraft to utilize those facilities. And again, City of Burbank versus the Burbank Pasadena Glendale Airport Authority states that local governments retain their power to regulate land use. In 2014, I wrote a letter to the city attorney, or I'm sorry, an email, and I asked her what agreements have provisions that state that we must have aviation tenants. And her response was, I agree that there is only one leasing provision in the 3 major contracts. Unfortunately, the FAA interprets the grant agreement relating to the exclusive rights and unjust discrimination to compel leasing practices favorable to aviation interests. See you tonight, Marcia. So let's look at the grant agreement and see what it says. The grant agreement, the 2 provisions that she cited were provision 22 and 23. The first one is on economic discrimination, and it states the proprietor will make the airport available as an airport for public use on fair and reasonable terms and without unjust discrimination to all types, kinds, and classes of aeronautical uses. So under this proposal, we will comply with that. Any aircraft can use the airport. They can take off and land. We're not trying to restrict any type of aircraft from using the airport. The B portion of item 22 is that any agreement to conduct aeronautical activity for furnishing services to the public at the airport, the sponsor will require the contractor to do the following 2 things. furnish services on a fair and not unjustly discriminatory basis, and charge reasonable and not unjustly discriminatory fees. And the reason that they want this is because they don't want the proprietor to say, okay, I'm going to sell fuel and I'm going to charge you $10 a gallon for fuel when you can buy fuel on the open market for $4 a gallon. They wanted everything to be fair to the proprietors. They didn't want to let one service proprietor in there and say, okay, only one person can service your engine, so he can charge 3 times the rate that somebody charging a market rate would charge. So again, if we get rid of all aviation tenants, if we don't allow any services there, there is no discrimination, so we would comply with that provision if we had no agreements at the airport. Provision 23 prohibits exclusive rights. And so, again, if you have no aviation tenants, then there is no exclusive right. If you have one aviation tenant, then you have to have 2. If you have 2, then they can argue that you only have 2, they can argue that you're discriminating against them. So if we have no aviation tenants, then we cannot be attacked on either of these provisions. So again, summarizing what I just said, if the city allows any aviation business, we have to allow 2 to avoid the exclusive rights. If we allow 2, then any other aviation business can sue on economic discrimination and exclusive rights. So the conclusion is allow no aviation tenants through the leasing policy. Okay, now we're coming back to what is the penalty for violating the grant agreement. So we come back to Section 49 U.S. Code 47-196, which says their secretary may withhold approval of an application for violating an assurance or a requirement of the subchapter. Now, when we read this, when I read this, when Ivan reads this or hears this, Ivan's response is no, they have other rights. They can issue cease and desist orders. They can do other things to us besides this. And he's right. In certain circumstances, they can. So when we attempted to implement the Class C and D jet ban in 2008, the FAA issued a cease and desist order and obtained a temporary restraining order against the city. And so, we filed a motion to dismiss this, but the court granted the FAA's motion and stated that we didn't provide any case law supporting that the FAA didn't have this right. Now, I absolutely agree with the city's position that the FAA did not have this right. I just think that we didn't prove our case, and that's why we lost, and the FAA was able to get the restraining order. In that same lawsuit went through a director's determination or an FAA hearing, and it concluded a director's determination. And then in 2011, we appealed that determination to the Court of Appeals. And so the Court of Appeals cited this in their ruling, and first they said that the finding Hall's and Trimborn's testimony to be vague, not specific to SMO, and not grounded upon scientific or engineering analysis, the FAA concluded that the preponderance of substantial evidence supported Marinelli's conclusion that overrunning the aircraft was unlikely to reach the private homes beyond the ends of the SMO runways. Next paragraph. As the foregoing review of the FAA's intermediate conclusion demonstrates, each conclusion was rationally based on substantial evidence in the agency record, and there is no evidence that the FAA based its conclusions on irrelevant factors or that the FAA made a clear error in judgment. So essentially what the Court of Appeals told us is that we didn't prove our case. First, on the injunction, we didn't supply case law to prove our case, and here we just used anecdotal evidence to attempt to prove our case. The FAA overruled us, and the court agreed with the FAA because we didn't provide substantial evidence that an overrun could hit houses, and therefore our C and D jet ban was appropriate. So we didn't lose, we failed. We didn't prove our case. And so the FAA isn't omnipotent, and they don't get deference from the court. We just didn't do a good job. Now, I read every one of our motions, and I thought every one of our motions were excellent when I read them. And then I read the FAA's motions, and I thought every one of the FAA's motions were excellent when I read them. And so I believe that the court was fair in this process, and I believe that we just didn't prove our case. So does that mean that we shouldn't do anything going forward because we're concerned that the FAA is going after us? No, we have rights. We have very clear rights as proprietor. We have case law that substantiates our rights. We have the operation of the parties where we've been leasing space to non-aviation tenants. The airport is currently 88% occupied by non-aviation tenants. So I believe that we have the right to do this, based upon the operation of the parties. So again, in conclusion, the city failed to provide case law and to provide evidence to support its positions in the Class C and D jet ban. Okay, in summary, in 2014, then Councilmember McEwen proposed the historic airport visioning motion, which was amended by then Councilmember Vasquez and unanimously approved by the City Council. It was the first true step. We had gone through the visioning process for 3 years, and it was the first time that the community felt like we were actually getting a vision for what was supposed to happen at the airport. What was proposed is slightly different than this, and this has changed slightly because since that time we've had the election where Measure LC was passed, and so this has been modified to suggest or to make it consistent with the Measure LC mandate. But number one is all leases be allowed to go to month-to-month tenancies, which will provide maximum flexibility for planning pursuant to Measure LC mandate for parks and playing fields. Number two, all rental rates charged at market rate to eliminate the gift of public funds subsidies to the wealthy users and for-profit businesses at the airport. Number three, eliminate tenancies that are incompatible with neighboring residential land uses because they are not required by any of our agreements after July 1st, 2015. As such, the City Council cannot be compelled to maintain these tenancies under an injunction. And let me just stop on that point for 1 second. We had an injunction against us on the jet ban because our agreement said we can't unjustly discriminate against any class of aircraft. It was written in one of our agreements. And so here we have only one agreement, as Marcia agreed with, that says that we have to have aviation tenants. That expires on July 1st, 2015. So we don't have to have aviation tenants after that expires. And number two, we have case law, which I presented up here tonight, that supports our position that we don't have aviation tenants. And the other thing that we failed on the C&D jet ban is that we didn't provide case law to support our position. So both we have no agreement and we have case law to support our position. So we can eliminate tenancies that are incompatible with neighboring residential uses. Number four is the exact same. Eliminate fuel cells because these are not specifically required under our agreements, and we can't be compelled to do it because none of our agreements state that we have to do it. Again, same argument. Number five, in March of 2014, they proposed to decommission the aviation, or from aviation use, the westerly quitclaim parcel. We also proposed paying back $250,000 of grant funds, but that's actually unnecessary because under a grant agreement, if you fail to comply, you don't have to repay the funds you've taken. You are only ineligible to receive future funds. Number six, develop concept plans with full public participation for the future use of the airport. This was recommended by staff. And number seven was commence phase one of the environmental assessment process. This was also proposed by staff. So I agree that we again should pursue these items and attempt to get these into legislation in March of 2015. Now that we've had the opportunity to go through the Measure LC election and get a full public mandate of what we want to happen at the airport. Thank you.